Hello, welcome to the December 7th, 2017 Coffee Break with the Hub. This is Suzanne Samuelson, Pre-Award Specialist in the UW Extension Office of Extramural Support. Today, I will be speaking on pre-award negotiations, what we can and can't do. Topics covered during this session will be who can sign a contract, who negotiates a contract, what is a contract, what should be included in a contract, what terms might create problems or issues, and how long will it take to finalize a contract. The next couple of slides will touch base on a couple housekeeping issues, such as who can sign and who negotiates a contract. The Board of Regents of the University of Wisconsin System has delegated authority to each campus to sign contracts on behalf of the regents. Only those individuals with such authority can sign a binding agreement. Individuals at UW Extension with delegated signature authority are UW Extension Vice Chancellor for Administrative and Financial Services Steve Wildeck, Associate Vice Chancellor Mark Dorn, and UW Extension Controller Margaret Erickson. Rhonda Loger, Director of Purchasing Services, has authority to sign procurement contracts, and Jordan Ott, Director of the Office of Extramural Support, can sign proposals and contracts for federal and non-federal sponsored projects. Take heed, it is very important to understand the significance of signing contractual agreements without delegated authority. If a legal issue develops that involves an agreement that was not signed by an authorized representative, the individual who signed the contract may be legally held responsible and not covered under the state liability program. It is highly unlikely that the unauthorized signature of the contract may be considered outside the scope of employment for that individual since they did not have the authority to sign. Consult with your local administrator or business services if you have a contract requiring signature. Those involved in the signature process for UW Extension are typically also involved in negotiating a contract. For purposes of this presentation, the Office of Extramural Support has trained staff who negotiate federal and non-federal sponsored project agreements. Currently, the pre-award specialist negotiates terms and conditions of sponsored project agreements. The pre-award specialist will work with UW System Legal Counsel and UW Extension Administration if they are unable to negotiate acceptable terms directly with a sponsor. You will soon see why a project director and his or her staff should not negotiate terms of a contract. A contract may be labeled in many different ways. It may be called an agreement, letter of agreement, memorandum of understanding, a memorandum of agreement, a letter of understanding, a purchase order, a cooperative agreement, a grant agreement, or a contract. In any case, don't be fooled. It doesn't matter what the document is labeled. If it creates a legal obligation on the part of the UW system and another party, it is a binding contract. There are generally two parts to an agreement, the main agreement and its attachments. The main agreement should include, at a minimum, clauses that address the following issues. The parties to the agreement. The parties to the agreement should be clearly indicated. The proper legal name of the sponsor, as well as the proper legal name for UW Extension, which is the Board of Regents of the University of Wisconsin System, University of Wisconsin Extension, must be stated. The term of the agreement or project period should be indicated. Sometimes there is also language regarding possible time extensions included in this clause. The total amount of the award should be included. If funding is allocated in increments by a different budget period as compared to the total award period, the budget period should be stated. There should also be a clause in the contract that states who the principal investigator or project director is for both parties. In some cases, it is referenced as key contact or key personnel. There should be language in all contracts that clearly outlines frequency of reports, both project and financial, along with specific deliverable dates. Project directors should carefully review all due dates for deliverables to ensure that such dates can be met. A clause should be included that outlines whether funds will be released on a cost reimbursable or a lump sum basis should be included. Language should be included to indicate if the contract is fixed price, based on deliverables for a fixed set amount of money with no refund. The work is done for a set amount, whether it covers all expenses or has an unobligated amount remaining at the end of the term. If cost reimbursable, the language should state how often invoices should be submitted, such as monthly, quarterly, or some other interval. If fixed price, a payment schedule should be indicated based on deliverables. Typically, some funds should be given upfront upon contract signature. There should also be an indication of when the final invoice should be submitted. If there is language in the contract requesting that UW Extension include copies of timesheets, invoices from vendors, travel documentation, or other backup information, OES will attempt to negotiate deletion of such information. This type of backup documentation requirement is often referred to as a desk audit. It can be quite burdensome and unnecessary since the sponsor typically would have the right to audit such records on site. However, there are times when such language cannot be removed. In such instances, OES will discuss this with the local grant administrator, so it is understood that department or division will have to maintain and provide this documentation. Sometimes the sponsor requires special financial reports. In these instances, the department and/or division will need to work with OES on preparation of such reports. A clause should be included that outlines the ability for termination. Both parties should be able to terminate. If termination is due to breach, UW Extension should have the opportunity to remedy such breach. If there are non-cancelable commitments on the project that cannot be canceled, perhaps due to a binding obligation to a third party for services or goods that can't be canceled, then negotiations should be allowed for the parties to determine final costs in order to cover obligations up through termination date. A clause should be included to indicate how communications and/or notices will be rendered to the other party, either via registered mail, email, etc., and to whom such notices will be delivered. For UW Extension, sponsored projects notices should be sent to the Office of Extramural Support. The second part to a contract is often the attachments. The attachments to the agreement may include a full proposal if applicable. If a full proposal was submitted, it should be attached or at minimum referenced in the main agreement. A scope of work. If a full proposal was not submitted, then at minimum, a scope of work should have been provided to the sponsor and attached or incorporated into the agreement. It should clearly state what services will be provided and when such services will be completed. A timeline and set deliverables may also be incorporated. This scope of work requires the project director's scrutiny to determine that such deliverables can or cannot be met. As an example, OES recently received a complicated contract from a sponsor. It wasn't until OES discussed other terms with the project director that it was discovered by the project director that the deliverables were unrealistic. OES most likely would not have noticed this because OES staff does not have the technical expertise to determine what is or isn't appropriate as a deliverable. A budget should be included. A fixed price contract should include a budget based upon deliverables. The budget should show lump sum amounts per deliverable or fixed amount based on an hourly wage. F&A, or indirect costs, should be included in the total cost. Fixed price contracts should not include budget line items. A cost reimbursable contract should have a budget based on major budget categories such as salary, fringe, supplies, travel, publications, other expenses, and associated indirect costs. There may also be additional conditions attached. Sometimes a federal agency will have additional regulations that are applicable to the contract. If the funding is a pass-through agreement, then the prime awarding agency terms and conditions should be attached. An example here is, say, Minnesota received an award from the USDA Farm Service Agency. UW Extension receives a subaward from the University of Minnesota. The contract to UW Extension should have Included as an attachment a copy of the award that Minnesota received from USDA FSA, along with any additional terms and conditions. Many terms and conditions create problems from a university policy or procedural perspective. 5 of the top problematic topics are intellectual property, publication, data ownership, confidentiality, and audit. Intellectual property, which includes patents, copyright, and computer software, are regulated not only by federal law, but also under UW system policies. This subject matter would take a great deal of time to discuss in depth, so I just want to point out to you that intellectual property is a complicated issue and should never be taken lightly. Clauses related to intellectual property will be discussed in depth with the project director before proceeding to finalize contract language. Agreements currently in effect, which are funding projects under the direction of the same project director, need to be considered and reviewed to determine what rights may have already been given to another party. Terms like an exclusive license or data ownership are always red flags. Publication language can pose numerous problems. UW System Policy 342, which governs extramural support administration, prohibits entering into an agreement with a sponsor that doesn't allow UW Extension the right to publish the results of the work done under a project. As a public institution of higher education, it is our mission to disseminate the knowledge gained from our endeavors. UW Extension has an obligation to assure project results are made known to the general public. UW Extension cannot agree to sponsor approval of publications because such approval may never be granted. Any restrictions must be clearly spelled out as to what constitutes approval. UW Extension can agree to hold up publication only for a limited amount of time, so the sponsor has adequate time to review publications to protect their proprietary information. Under UW system policy, the transfer of ownership of data created under a sponsored project, excluding proprietary data of the sponsor, is not allowable. However, UW Extension can grant the sponsor the right to use the data. There is an exception. If the work being done is determined to be a work-for-hire arrangement, such work for hire is usually determined to be a deliverable. In such cases, the sponsor may own the deliverable, but UW Extension would request a license to use the data for further educational endeavors. However, whenever possible, it is preferable to indicate that UW Extension will own the data and grant the sponsor a license to use. Under the same UW system policy, all sponsored project contracts must be reported to the Board of Regents. Therefore, UW Extension cannot keep the existence of a contract confidential, nor keep confident the work being done under a sponsored project. Although it is acceptable for a sponsor to audit UW Extension records, advance notice should be given by the sponsor before showing up at our doorstep for the audit, and UW Extension will not provide a desk audit. A desk audit is where UW Extension agrees to provide copies of invoices paid, hourly salary detail, travel documentation, etc. In addition, there may be some unusual audit requirements that will need UW Extension administration's approval. For example, UW Extension currently has agreements with a specific sponsor who requires an outside auditor on an annual basis complete a special audit report. This imposes additional costs on UW Extension and is highly discouraged but was unavoidable with this sponsor. We also have a contract in place with a federal agency where they require us to get travel backup documentation from all of our subawardees on the project. This is very time-consuming for the department to obtain the documentation from subawardees and can be quite burdensome. There are numerous clauses in a contract that could pose legal ramifications. Some of the major problematic contractual terms relate to confidentiality, audit, liability and indemnification, governing law, jurisdiction and venue, insurance, arbitration, and miscellaneous remedies. Earlier, I indicated that confidentiality language could be a potential problem under university policy and procedure. Matter of state law. UW Extension, as a Wisconsin state agency, is subject to Wisconsin statutes. As a public institution, we must be able to disseminate the results freely. If there is a public records request involving the sponsored project, as a courtesy, UW Extension should inform the sponsor, and UW Extension may need to work with the sponsor to protect their proprietary information from being disclosed. Also, as previously discussed, there are university policies and procedures surrounding acceptable audit language. In addition, there are federal regulations that apply under 2 CFR 200 subpart F. These regulations are quite lengthy and I will not go into them. The important thing you need to know is that UW Extension is subject to these regulations and must have an audit done annually. Liability and/or indemnification is a major language hurdle, especially when dealing with nonprofits and for-profit entities. UW Extension is subject to Wisconsin statutes governing liability. Therefore, UW Extension cannot indemnify, or in other words, agree to hold another party harmless for something they do illegally. UW Extension can only indemnify our employees or agents while acting within the scope of their employment. In addition, we cannot agree to pay for the sponsor's legal fees. There are some instances where it may be determined to purchase indemnification insurance, but it is a cost that must be borne by the department involved. It can be expensive, and UW Extension does not always permit such purchase, depending on whether the risk outweighs the benefit. Governing law, jurisdiction, and venue are other complicated areas of contract negotiation. UW Extension cannot agree to laws of another state. By doing so, it may be perceived that UW Extension is waiving its sovereign immunity. Sovereign immunity means that the state of Wisconsin cannot be sued. Since the state of Wisconsin is covered under sovereign immunity, any legal action or lawsuit must name an individual. Such named individual, if acting within their scope of employment, is covered for liability under the statutes. UW Extension is precluded from agreeing to specific venue of another state's court because only the Wisconsin legislature can agree to such venue. In many instances, UW Extension is able to resolve some of these issues by playing silent to governing law and/or agreeing to language that simply states suits may be brought in a court of competent jurisdiction. The self-funded liability insurance program governs UW Extension as an agency of the state. Sometimes a sponsor will want us to extend such coverage to them. However, under the state's insurance program, UW Extension cannot name the sponsor as an additional insured. UW Extension can also not agree to binding arbitration because, once again, any judgment must follow Wisconsin state statutes in regards to filing such claims. If language agreeing to binding arbitration cannot be removed, then there must be a requirement included that the arbitration award against UW Extension will be submitted to the State Claims Board for approval. There are numerous miscellaneous remedy clauses seen in contracts, such as the ability of the sponsor to sue for specific performance, entitlement to cover court costs and attorney fees. Such clauses are prohibited under the Wisconsin Constitution, and there is case law as precedents. Under contract law, the type of lawsuit and damages will be determined by the appropriate court. Last but not least, you are probably wondering how long it will take the Office of Extramural Support to negotiate a contract or award. Well, that depends. OES staff resources, such as vacations or vacancies, will have an impact on award negotiations. Also, keep in mind that proposals for funding take precedence. If there aren't any proposal deadlines and a contract is received, OES staff will begin to review the contract as soon as possible. Before proceeding with negotiations, OES needs approval of the award document from the project director. Discussions between OES and the project director may be delayed if the project director is on vacation or in the field. However, the project director's comments need to be taken into consideration and discussed prior to and during negotiations. In addition, it depends on the timely response from the sponsor. As an example, OES recently worked on a contract with an agency for federal pass-through funding. Negotiations began in April. However, the sponsor wasn't responsive to requests for further negotiation. The contract had been with legal counsel for 2 months, and they could not get the sponsor to respond. It was only after various tactics were deployed by OES that the contract negotiations finally concluded and a contract was signed. It took 6 months to finalize. Federal or nonprofit foundation grant agreements usually include clauses that are generic and standard, and nothing or only minor changes may need to be made. In these cases, such grant agreements are typically signed within 2 to 3 days. For a non-federal agreement or a federal cooperative agreement, it could take 1 to 2 weeks because there are more problematic clauses involved. Now, if the award is a federal contract, it could take up to 4 weeks or even longer to finalize. Federal contracts involve the federal acquisition regulations that are basically federal red tape. They are numerous clauses, lengthy, and time-consuming to review. In many instances, the federal grant specialist doesn't want to take the time to carefully draft the contract with appropriate clauses, so they will throw in clauses that aren't even applicable under the regulations. Therefore, it can take days to review and determine which clauses should really be included in the contract and negotiate correct terms and conditions. Overall, the typical turnaround for negotiating a grant award or contract is probably 1 to 2 weeks. In closing, the Office of Extramural Support is committed to serve its faculty and staff, as well as its sponsors, by effectively and quickly finalizing documentation to bring in extramural funding for its educational and outreach programs. If you are a project director on a sponsored project or a local grant administrator in a department and you receive a contract related to sponsored projects, please contact your divisional grants office first. They will provide instructions on how to proceed with processing the contract. If you or your divisional grants administrator have additional questions, please contact the Office of Extramural Support. Either Suzanne or Jordan will gladly talk or correspond with you on what the next steps will be. Thanks for listening in today, and be sure to check out what's up next at Coffee Breaks with the Hub.